Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we have breaking news out of Florida. The jury has reached a verdict in the penalty phase for Jason Banegas.
As you know, he's facing the death penalty after he pled guilty to first-degree murder in the death of police officer Yandy Chirino. And now it's up to the jury to decide whether or not to recommend death or, in the alternative, life in prison for Banegas. Let's listen in.
Can we wait for a couple of minutes?
Sure.
Thank you.
Okay. You guys can have a seat. Obviously this has been a very emotional trial. Have a seat. Emotional trial on both sides. Whatever this verdict is, I expect there still to be decorum in the courtroom. I don't expect any yelling, whooping it up, regardless one way or another. So please, whatever this verdict is, just as you're stoically now, please remain that stoic. Defense, you tell me when you want me to bring him out.
I understand, Judge. We just need a couple of minutes for my client's family to finish arriving their parking right now.
Oh, I'm sorry. I did not realize that.
Thank you.
And they're just pulling in now, you mean?
They're on the elevator.
They're on the elevator. Okay. All right. We can wait. We can wait.
You know, Michael, I had the privilege of watching your coverage during the last couple of hours and listening to you, your guest, as you're talking through this. And I think this jury, I mean, a dumb thing to say, but what a weight on their shoulders to make a very hard decision in this case.
No doubt about it. I mean, there are legitimate mitigating factors.
Yes.
And ones that we've seen work before when you have a really traumatic upbringing. And I don't think there's any... These are the people that we were waiting for just arrived, folks. Again, this is a live picture of that courtroom. The judge wanted to be respectful and wait. It looks like this is part of the Banegas family.
Yeah, those are the ones the defense said, can we wait for them? And he just reminded everybody, please, I expect decorum in the courtroom, so you're not going to act out regardless of what that verdict is.
Speaking of decorum, quickly, what did you think of the defense attorney's pretty emotional closing? Gotten to the point where she was actually crying and really begging this jury for mercy.
I felt like it was very, very sincere.
Okay, for those of you who just arrived, I mentioned earlier that I know this has been a very emotional case on both sides. When this verdict is read, whatever it is, I expect decorum in the courtroom, no yelling, screaming, anything like that. So if we're ready, go ahead and bring the jury out.
While the jury comes in, what I wanted to say was she was very passionate, believable, but I liked the point you made, which was she was emphasizing he'll never get to hug his kids again. Well, the victim won't either, and I don't know how that played to the jury.
Yeah, and I thought she went at it really hard.
She did. I agree with you.
To this jury. And, you know, I wonder if that was the right tact. Because, again, this is a horrific crime.
Yes.
And family members are in there who belong to the victim in this case. So you have to be mindful of that as well.
And you remember we heard from the head of law enforcement, and I'm not sure, I can't recall if he was captain, what the head of it was, but he spoke. He got up there and spoke about losing one of your own and how horrible and hard it is. But this defendant was only 18 at the time. I think that's a pretty big mitigator. It's
a serious consideration for this jury. Again, this was a crime against not only the victim, but the community as a whole, based on the fact that this was a peace officer. All right, we're just going to get you into that courtroom now. We're expecting the verdict to be read in any moment.
Okay, please be seated. Ladies and gentlemen, it's my understanding you've reached the verdict. Is that correct? Yes, sir. Would the foreperson please hand the verdict to a deputy? Do we have the jury instructions there?
Yes, Judge.
All right. Give the instructions to Tom. Let me have the verdict form.
Yes, sir.
In the case of the state of Florida versus Jason Banegas, case number 21-9866, CF10A, we, the jury, find as follows as to Jason Banegas. A, aggravating factors as to count 1. We, the jury, unanimously find that the state proved beyond a reasonable doubt that at the time of the first-degree murder, Yandy Chirino was a law enforcement officer engaged in the performance of his official duties. And yes is checked. We, the jury, unanimously find that the state proved beyond a reasonable doubt that Jason Banegas was contemporaneously convicted of a felony involving the use of violence to another person. No. We, the jury, unanimously find the state proved beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. No. Mitigating circumstances. One or more individual jurors found that one or more mitigating circumstances were established. Yes. C, weighing aggravating factors and mitigating circumstances. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. If you, we have a problem. If you answered yes to Section C, please proceed to Section D. If you answered no to Section C, do not proceed. Jason Banegas will be sentenced to life in prison without the possibility of parole. So say we all this 15th day of December, AD 2025, Fort Lauderdale, Broward. Now, ladies and gentlemen, members of the jury, I'm going to ask each of you about the jury's decision that you have just heard. Do you, Victoria Riley, agree that the decision...
Michael, that was an interesting, hang on, we have a problem, the way he read it. As I understand it, the last words were life in prison is what this jury has recommended.
Yeah, I think he tripped over the section where it was whether aggravating factors outweigh the mitigating factors.
I agree.
He said the aggravating factors, at least the jury said that the aggravating factors outweigh the mitigating factors. I think that's wrong.
Right.
I think he meant the mitigating factors, in fact, outweigh the aggravating factors, and they found that he should be sentenced to life in prison without the possibility of parole rather than death.
I agree. It had to have been that, and I agree with you that at the end of the day, that's what he said. Just so you're aware, as you're listening along with us, he is asking each individual juror now if that is in fact what they recommend, pointing out that the death penalty does not require a unanimous decision in this state. It's at least 8 of 12 in Florida, but here we have it. Life in prison is recommended.
Yeah, and in fact, you know, that's still under challenge. That's,
oh, yes, with the Supreme Court there.
Supreme Court's still looking at that, so we don't know how that's going to turn out. But I found it interesting that in terms of the aggravating factors, there were 3 to consider, and 2 out of the 3 they did not find. They found that he was a police officer in performance of his duties, but as far as that it was contemporaneous with a felony versus a person, they found that did not exist. And also, it wasn't an especially heinous or cruel crime, which I found surprising.
I did too. That's the one I wrote down because I thought, well, I expected them to say yes as to that one as it aggravated, but you're right, they did not. And they didn't individually list the mitigating factors that I thought was interesting. Right now, let's bring in criminal defense attorney Marie Pereira and also joining us now, former prosecutor Tommy Pope. Tommy, let me start with you. Your thought as you hear that this jury has decided, they have spoken, their recommended sentence, life in prison, and we know a judge cannot change that. A judge could go from death to life, but they can't say life to the death penalty. So this young man, I say young man, he was 18 at the time, now facing life in prison. Tommy, your thoughts?
It's always difficult for the family. I think they have a desire to feel like they've done everything possible for their loved one. But as a practical matter, true life without parole is actually a better sentence for the victims. Now, they won't feel that today, and it was disappointing to hear they didn't think shooting a police officer was heinous or contemporaneous with the commission of a violent crime. But ultimately, he'll become a number, and they'll be able to move on with their life. As we all know, when it's a death penalty, you may try it 2 or 3 times. It becomes the, Jason Banegas case instead of remembering the victims. And I've unfortunately had that time and time again in death penalty cases I've dealt with. And so,
all right, Tommy, I'm
what
gonna have to
seems
cut
like
you
a
off,
loss
buddy.
for the family.
Tommy, I'm sorry
Sure.
to have to cut you off, but it sounds like
Sure.
the judge has
Yes,
finished polling the jury. Let's get back in the courtroom.
Nancy O'Brien
Yes, sir.
and Nelson Morgado. Ladies and gentlemen, at this time I'm going to discharge you. You are free to talk about the case with anyone you want to. You do not have to talk to anybody you don't want to. You are not compelled to talk to anyone you don't want to. If anybody hassles you as you leave here, Maria will be with you. She'll take care of that. So again, with my thanks and the thanks of all the judges here and everyone in this courtroom, I appreciate the effort you've made. Thank you, and you're excused. Okay, please be seated. Okay, with respect to the issue of sentencing, I have February 18th available. Do we need the whole day? I know there are other victim impact statements that might want to be given. I suspect on the other issues, the other charges, there may be something from either side. Is February 18th okay, and do we need a whole day?
It's fine. I don't believe that we need the full day.
Okay, if we did the afternoon of the 18th, from 1 o'clock or 1:30?
I think that should be fine enough. If there's an issue, we can just start earlier.
Okay. All right, then we'll set this for sentencing on February 18th at 1:30. Anything else we need to discuss?
Not from the defense.
Not from the state.
Okay, thank you. Then we are in recess. Now I gotta turn this in.
All right, so there you heard the judge setting sentencing for February 18th, expecting extensive victim impact statements, and I'm sure there'll be other statements as well, perhaps some from the defense. Let's bring back in our guest, criminal defense attorney Maria Panetta, still with us, and also joining us, former prosecutor Tommy Pope. But Maria, I want to start with you here. Were you surprised at the aggravating factors? There were 3 being requested by the state. Only one was found, that he was a police officer in the performance of his duties. The others were not. In particular, that this wasn't an especially heinous or cruel crime. But what are your thoughts?
I'm not surprised, and that's why I said earlier, they look at the totality of the circumstances. How did this encounter happen? Did the defendant go out to actually commit a felony, encounter a police officer who was doing his job, and intentionally shot the police officer twice in his face, blowing his teeth out of his mouth? That's not the way it happened. So I think the jurors were very thoughtful to look at the entire factual pattern here and look at the mens rea, and they came up with what they did. But I want to go back to the delivery of the defense attorney. While I think she was tenacious and did a good job at tugging on the heartstrings, somebody should have checked her for that crying. It's unacceptable, unprofessional. Imagine if the prosecutor burst out in tears when he was delivering his closing statement to promote the death penalty, to start crying and say, "Oh my God, look what happened. Please give me justice." They would never allow that. They should have shut her down with the crying part. That's all I'm saying.
And I have to weigh in on that. I don't disagree with you. It's hard. We're emotional about the cases that we try as attorneys, regardless of the side we might be on. But to your point, Marie, I think it is very important that you check that emotion at the door, because you're right. If the state had done it, it would be argued as prejudicial and probably a motion for a mistrial. So you make some good points there. Now, the other thing, Tommy, and I think this goes in along with what you said about victims, after they have time to sit with it, may realize the life in prison is okay, right? Is okay at the end of the day. The decorum, the judge said you need to keep the decorum. Everybody did. We just watched. Everybody was very appropriate listening to this verdict. But also, I think the thing that stood out to me was the defendant himself. He looked relieved. He looked like, you know, weight off his shoulders. But let's keep in mind, he's in jail the rest of his life. There's no getting out of that unless there's an appeal and it's overturned. That's his life.
In a strange way, I thought that the fact that the sentencing sheet was a little disjointed and maybe something was checked wrong on it probably helped kind of keep the courtroom settled, because it wasn't clear. I mean, like you said, when he said aggravated, you know, of course, we never weighed them. We had, you know, you presented aggravated, presented mitigated, and clearly one mitigation, like his age, could overcome whatever heinous nature the crime was. But it was interesting watching the defense counsel when they said, you know, it was like a roller coaster. You know, you hear these, and when they don't do the two other aggravators, you go, well, I see the way this is heading. And then when he said the aggravating did outweigh, then I think we're heading back the other way. So it had to be an emotional roller coaster. Speaking of emotions, I'll say I was watching last hour or two, and I agree with what Marie just said and what you guys said. There's not a place, and it could be a lot of different reasons. I don't know the attorney's experience level. You know, we can't become too attached to our victims or to our defendants. And again, the crying in the closing, I remember specifically in the Smith case having to cut off my direct because I was enlisting from David Smith, the boys, and losing them. And when he found out that she had drowned them and all that stuff, and I was about to burst into tears, and I knew that wasn't permissible. And so I cut my direct off earlier and had to leave the courtroom. So, I mean, we're all human. You can have that, but I think you have to control it, and it could have been an objection.
Yeah,
if the defense, I mean, the prosecution had chosen to.
Yeah, and I wonder if a little more leeway was given because it is the penalty phase.
Yes.
You know what I mean? Certainly if this
so.
was the trial phase, there would have been issues.
I think so.
But I think because it was a penalty phase.
And death was on the table. I mean, that's the most serious of all. So I do understand for that reason. That could be why.